Yes, Professor Amber, we can start.
Thank you very much, sir. Over to you, Sidra.
Good evening to one and all present in this August gathering. A warm and hearty welcome to each one of you gathered here today at Symbiosis Law School, Nagpur, to attend the panel discussion being organized by International Cell and Training and Placement Cell in collaboration with Law Essentials and Knowledge Partner, Optimus Resolution and Restructuring Advisors LLP on navigating the evolving landscape of solvency and bankruptcy perspective from India, Canada, and Singapore. We are elated to have with us today distinguished panel member Dr. Pyla Narayana Rao, Dr. Paul Frenchy, Mr. Pramod Srihari, Mr. Prakul Thadi, and Mr. Mohammed Farhan C. Symbiosis Law School Nagpur has always prided itself on providing a platform for holistic learning, where our students imbibe not only the complexity of legal framework, but also the richness of varied perspectives from around the world. Our international cell stands as testament to this commitment, creating opportunities for our students to engage with global luminaries and leaders. We are also blessed to have with us our director, Dr. Sukhwinder Singh Dari, who, with his visionary leaderships, unwavering commitments, and steadfast dedication, is leaving no stone unturned in providing the student community with opportunity to expand their horizon. Now, I would like to invite our director, Sir Dr. Sukhwinder Singh Dari, to kindly deliver the welcome address.
Thank you. So, good evening. A very warm welcome to the highly anticipated panel discussion on navigating the evolving landscape of insolvency and bankruptcy, perspective from India, Canada, and Singapore. It's my distinct pleasure to extend my heartfelt greetings to our esteemed panel members and enthusiastic audience of budding legal minds. So, today's panel discussion that promises to be both that is enlightening and enriching as we explore into the complex domain of insolvency and bankruptcy from diverse international perspectives. The collaboration of esteemed professionals from India, Canada, and Singapore represents the global interconnectedness of legal practices and the importance of cross border knowledge exchange. I'd like to extend a special welcome to our esteemed panel members, Dr. Pyla Narayana Rao, Associate Professor at Indian Institute of Corporate Affairs, Mr. Paul Franchi, Licensed Insolvency Trustee from Ontario, Canada, Mr. C.S. Prakul, Partner at Prakul and Kunwarpreet LLP, CA Pramod Srihari, Insolvency Professionals, Partner at Pramod and Darshan, and Mr. Mohammed Farhan, legal in-house from Singapore. Thank you so much, and I welcome you. I believe that your expertise and insights will undoubtedly provide an invaluable perspective to our eager law school students and enrich their understanding in the complex field. To our audience, I encourage which comprises of the bright and ambitious mind of law school, I encourage you to actively engage in the today's discussion, observe the knowledge shared by our esteemed panelists, and seize the opportunity to broaden the horizons in the realm of insolvency and bankruptcy law. With this, once again, I extend my sincere gratitude to all the participants for joining us today. May this panel discussion serve as a platform for discourse and fruitful learning. Thank you. Over to you, Sita.
Thank you so much, sir, for your kind words. We at Symbiosis Law School Nagpur view guest lectures, seminars, webinars, etc. as a platform where we collaborate with elements, personalities, and use this platform to spread knowledge to support learning beyond the classroom. This panel discussion is a sincere effort in the same direction, and this I would like to invite our first panelist, Dr. Pyla Narayan Rao. Sir is an associate professor with School of Corporate Law and School of Competition Law and Market Regulation at IICA. Sir is also a nodal officer from IICA to Insolvency and Bankruptcy Board of India. Sir is one of the key persons for bringing the postgraduate insolvency at IICA and acted as course coordinator, GIP, and nodal faculty of Center for Insolvency and Bankruptcy at IICA. Sir has acted as course coordinator of the prestigious National Company Law Tribunal for honorable members of NCLT organized at IICA as an induction and refresher program. I would like to request Sir to enlighten us with his insight on the general overview of IBC in India, regulatory bodies and agencies.
Yeah, thank you for the opportunity. And from Symbiosis Group of Institution, it's my privilege to be part of such an esteemed panel for speaking about the insolvency and bankruptcy regime in India. As you can see from since 2016 December to till date, the kind of impact the insolvency and bankruptcy has brought in India. It is quite evident because we are lucky to see the growth of IBC since starting of the first day. So what made the insolvency and bankruptcy in India to create such a great impact on the restructuring, reorganization of companies, especially in the context of resolution process, is quite evident from the number of cases that were filed at NCLT, NCLAT to Supreme Court. And I think around almost 170 plus orders from Supreme Court in a span of 7 years on a single legislation is a quite remarkable achievement, in the sense like the way the stakeholders are active in this law. If the stakeholders are not really like this law, that this kind of litigation would never happen. And there was around 7 to 8 times the law validity was challenged by the stakeholders, especially in the case of the constitutional validity that is successfully elevated by the Supreme Court in all the occasions. That is another remarkable achievement. So overall, this law has brought an impact, which I'm going to divide it into different parts. So this law is basically known as a 4 pillars of IBC, which is contributed a great extent for the development of law. So the 4 pillars are divided into: first pillar is NCLT. The second pillar is insolvency professional agencies. Third, now latest is insolvency professional entities as well. And the third pillar is the Insolvency and Bankruptcy Board of India. And the fourth pillar is information utility. This is an innovation from IBC, and probably is the only institution named under insolvency law and across the world. There is no institution equal to information utility. So coming back to the NCLT, NCLT is the only institution named under this law for the purpose of resolving the dispute related to, the insolvency related to corporates and LLPs. Or to some extent under section 227, it talks about the resolution of the financial services as well, like banks, insurance companies, etc. And there is also an interface that NCLT takes up under this, is the resolving the insolvency of the personal guarantor to corporate debtors. And another adjudicating authority the IBC has named is DRT, Debt Recovery Tribunals, for the purpose of resolution of insolvency of individuals, sole proprietors, and as well as the partnership businesses. So this is the way the adjudicating authority is named. NCLT now entrusted with all the consolidated corporate jurisdiction under IBC, and that has been entrusted to the institution called NCLT. The NCLT headed by normally 2 members, one is judicial members, second is technical members to look after these cases. NCLT is also empowered with all the powers of civil court with reference to their orders are concerned. Any order NCLT passes under this legislation is treated to be a decree of civil court, so that you can able to enforce it if you want under the Companies Act. Or otherwise, there are other mechanisms, like in case if you are contradicting the resolution plans approved by NCLT, you have a recourse to go to liquidation as well. But remember, NCLT orders can also be executed through company law process. It is clearly mentioned, and all the formalities like Limitation Act for filing of application before this tribunal, all the legal formalities giving an effect to the order as a judicial order, contempt of court, etc. Everything has been entrusted with this institution to ensure that the law not only stated, but it is also stated to get implemented as per the spirit and the letter. The second pillar that we are talking about today is that the entire process of resolution would be taken care by the insolvency professionals. So insolvency professionals, we have a dedicated test under the IBBI IP regulation that you can, with certain experience as an advocate or a cost accountant or a chartered accountant or a company secretary, or even through a process of graduate insolvency program that we are conducting since last 5 years at IICA. So the person with this qualification can apply to become an IP. So when he applies it, when he qualifies, he is required also to go through a pre-education course conducted by a frontline regulator called IPA, that is Insolvency Professional Agency, which is also one of the intermediaries under the IBC code. So all the institutions like IP, IPE, IPA, and the information utility, we call it as a service providers under the insolvency bankruptcy code. So the person who qualified to an insolvency professional is required to undergo certain courses continuously after his enrollment with IPA, which is a frontline regulator, which also regulates regulates and monitor the assignment handled by the members of this IPA. So, and also if required, any disciplinary proceeding orders, etc., need to be taken. This body is also competent under the code to take any action. So in above this, but we have the principal regulator, that is IBBI, where you ultimately, after the completion of these pre-educational courses, you can apply and get enrolled, and your name is also been published at IBBI website for taking any assignments as and when it comes. So this is how the frontline regulator and the main regulator IBBI and IPA works. And the insolvency professional information utilities and insolvency professional entities, even insolvency professional agencies, are subjected to the regulations of IBBI. So IBBI regulates, they don't leave anything unregulated. For IPs are concerned, we have insolvency professional regulation, including the code of conduct for insolvency professional if they are into any kind of disciplinary proceeding orders. Similarly, the IPA, which regulates the IPs, also have a insolvency bankruptcy code model bylaws regulation, how you should run that section 8 company that is called the IPA for the purpose of monitoring and regulating the assignments of the members and ensuring the best standards and best practices while handling the assignment by the IPs. So recently we also got IPE, which is also like the firm. You can open a firm through which you can provide the insolvency services. So like the way auditor and audit firm, auditor as an individual auditing firm as consisting of group of auditors, how they render the services, even IPE can also render services and take any kind of resolution process for the purpose of IBC code. So this is a new innovation, bringing a group of insolvency professional consisting of one place called IPE, which can also render services depending on the assignment. So IPE is also now regulated, though it has been named initially, but it is now got a recognition, statutory recognition to act as an insolvency professional. So this is IP and IPA and IPE. These are the three institutions and other than NCLT. Now we have the IBBI, Insolvency Bankruptcy Board of India, which is also an extension of the executive of the state, which is empowered like SEBI, like CCI or other institutions. This is a regulator. The main job of IBBI is to draft the regulations and to bring out the regulations for every subject that is part of IBC process, and all the regulations are complements the IBC code. For example, the recent amendments in IBC, for example, somebody want to withdraw the application. So IBC says that you can withdraw the application, but IBC doesn't provide in the code itself how to withdraw it. So withdrawal would be the modus operandi, how to withdraw application would be in the regulation. So the regulation part would be taken care by the regulator. So every IPs, IPAs, IPs even for transactions, even service providers, for everyone, IBBA has brought a regulations. In addition to the regulations, we also have a rules. The rules basically prescribe the procedure that how we should approach the NCLT in case of any case comes. So that procedure rules are called Application to Adjudicating Authority rules, which guides for you to take up your case under either Section 7 as a financial creditor, or Section 8 as an operational creditor, or Section 10, the corporate debtor itself can able to take the guidance from this Application to Adjudicating Authority rules. You can able to make an application and you can check whether you are covered under the definitions, whether you are covered under any section, whether you have a locus standi to approach the NCLT for making an application. So this is all about the process at one end. So normally what happens when you approach the courts, especially the tribunals, the first of all that you need to prove that you have enough evidence that to show to the court to admit an application. So this was a cumbersome procedure in normal courts because proving an evidence and checking the authenticity of evidence to show it to the court to admit the application would be a tough job. To reduce this, the Insolvency and Bankruptcy Code has introduced an institution called information utility, which is one of the most innovative thing that ever happened. That the information utility, you can see that we have NESL, National E-Governance Services Limited in Bangalore, that is floated by the 17 largest creditors in the country for the purpose of authenticating the information, storing the information from all the parties, which can be used as an evidence before the NCLT. In fact, NCLT is insisting now that every application that comes under Section 7 required to mandatorily to place the record that they have recorded with the information utility, which can be used as an evidence at prima facie to admit the application, so that the maximum time that normally takes in a regular courts can be avoided, so that the process can be time bound. This law is based on the non-adversarial procedure. It is against the regular usual procedure of adversarial procedure that where the court-driven procedure would normally follow. But IBC comes under the non-adversarial procedure. It is basically a not 100% court-driven procedure. The court will come only to ensure that whenever the resolution plan is approved, whether the plan is according to the laws or not. Right. So that is how the IBC works. It is completely driven and opposite to the earlier regime of what India follows, that is debtor in possession to creditor in possession. So our system is now completely changed to the creditor in possession. So it is all driven by the committee of creditors. So that is how the resolution takes place. In case the resolution fails, then you are required to go for mandatory liquidation process, unlike the individual insolvency, where the parties have autonomy whether to make an application for bankruptcy process or not. But in IBC, in the first part 2, it's a mandatory that in case of resolution is not happened, then you mandatorily go for liquidation, right? So these are the some of the facts when I talk about the 4 pillars. So, and also when you talk about the impact of how this Indian insolvency law has created a kind of impact, which I was talking about earlier, that you can see that IICA is at forefront from day one when this code has come, and we understood the requirement and the kind of stakeholders and the people who are looking at this code. So we started with the help of IBBI, we started a new course, 2 years full-time course in 2019. I myself involved from the day one, the course called Graduate Insolvency Program, which is a 2 years program and 1 year classroom, 1 year internship. So that course is well received by the market, and we have 100% placements since day first batch. And you might have heard already. Recently, the course name is also been changed to PGIP, that is Postgraduate Insolvency Program. So this is, and that again encouraged us to recently to come up with another full-time course of LLM in association with Nalsar University of Law, Hyderabad, and IICA together launched a 2 years LLM course again on IBC, where that the students would be stationed in the first year at Nalsar and second year at IICA. So these two are the best example to show, because in our country, or I have seen across the world, there is no anywhere a course of 2 years full-time on insolvency and bankruptcy ever. When I was working on in 2019 to see whether is any course of a stretch of two years. It is nowhere in the world. Even I don't think so, even till date is there any such courses ever. So it is our privilege, and you can see that these two courses are actually a full evidence to show that how much the IBC has actually brought to us and how it is working. And I'm sure that this is even too early to talk about it because the law is not even 7 years old. So by the time we cross around 10 to 15 years, this course will be very much integral part of every, because even if you teach someone that, even the faculties are not available because many people are looking at this law now. So by the time down the next 10 to 15 years, this will have a huge impact, and this would be like on par with like other branches of law, that it within the corporate law, you can say that there will be another serious branch to look into it, and students are also very much excited to be experts or wanted to study this law better for their employment opportunities. And you have seen the consultancy firms, law firms, ARCs, and you can say even the pre-restructuring companies like the pre-IBC consultancy firms. Everybody is recruiting students across the country, looking for the best for their own work. So I think these are the few inputs I have, that I hope I am sticking to the time. I have been given, I think, 20-25 minutes, and I spoke, I think, around 20 minutes. And thank you so much. If you have any question, I am available for any answers. Thank you. Thank you.
Thank you so much, sir, for your enlightening talk on IBC in India. Your valuable insights are truly enriching for all of us. Now, I would like to invite our next panelist, Mr. Paul Frenchheim. Mr. Paul is a licensed insolvency trustee at Bagel Corporation. Sir has served as director at Kunjar Sharma and Associates for 3 years. Sir has also served as director at Pinnacle Associates. Sir is the founder of Strike Equity and has worked independently as a consultant to the investment management and investment advisory community in US and Canada. Sir holds an experience as VP Head of Advisory Services at RTO Global Investors Limited for 9 years, prior to which Sir has served as Director Mutual Funds at TT Embry for 5 years. Before that, Sir has worked as an attorney at various law firms. Sir has published 2 insightful papers, namely Busting the 5 Myths of Insolvency in the year 2018 and Demographic and Decline of Equity Mutual Funds in the year 2013. I would request Sir to kindly address the panel on Canadian insolvency and bankruptcy laws.
Thank you so much. I hope you can hear me clearly. If not, just raise your hand and I'll know that I'm fading. I am so pleased to be invited by the esteemed Symbiosis University Faculty of Law. My respect to Director SLS Nagpur, Dr. Sukhvinder Singh, Dr. Pyla Narayana. I am a licensed insolvency trustee with Bagel Corp, which is a boutique insolvency firm in the city of Toronto, province of Ontario, Canada. It was founded 6 years ago by 2 very well-respected industry leaders, Mr. Michael Bagel and Jeremy Kroll. Bagel Corp's company tagline is that its members have been advising and rescuing small businesses for 3 decades. That's 3 10-year periods, which I understand shortly will become 4 decades. Bagel Corp is an IR global member, which provides us with a footprint in the global landscape. In Canada, like in India, several statutes regulate bankruptcy and insolvency. I will review the principal ones, and also I will take a page from Dr. Pyla's songbook, and I will formulate my remarks under his 4 pillars so that it'll be easier to kind of follow along from the Indian context. Our main insolvency legislation in Canada is the Bankruptcy and Insolvency Act. And I would compare that to your Insolvency and Bankruptcy Code of 2016. Like the IBC, the BIA, Bankruptcy and Insolvency Act, provides an institutional framework for the administration of bankruptcies and proposals for both individuals and corporations throughout all of Canada. I think the term proposal might not be self-evident, but that would be when Dr. Pyla was referring to the proposals driven by Committee of Creditors under the IBC. And I'll talk more about that. So also similar to the IBC, we do have the BIA constructs a framework for the insolvency regime. So working from Dr. Pyla's 4 pillars, I'll start with regulator. The Office of the Superintendent of Bankruptcy would be the OSB, Office of Superintendent in Bankruptcy. And the sister institution, I believe, would be your IBBI, Insolvency and Bankruptcy Board of India. Our institution contains the appointed post of the highest officer in the country in bankruptcy, notably the Superintendent of Bankruptcy. This post is currently held by a very seasoned bankruptcy lawyer, Superintendent Elizabeth Lang. Working on Dr. Pyla's second pillar, insolvency professionals. The Bankruptcy and Insolvency Act sets out the insolvency professionals, which we in Canada call licensed insolvency trustees, or LITs. These are regulated by the Office of the Superintendent in Bankruptcy. The OSB has licensed a private body to administer the course curriculum and testing for the education certification component for insolvency professionals in Canada. In order to become a licensed insolvency trustee today, one enters the CQP program, which is offered by the Canadian Association of Insolvency and Restructuring Professionals, or CAIRP, C-A-I-R-P. Now, like Indians, Canadians have fun with acronyms, and we like to try to confuse each other the best way we can. So if I were to compare it in the medical equivalent, by comparison, if I were to become a doctor in Canada, I would first complete a medical degree in university to be entered in for consideration to become a doctor. So the medical degree equivalent in Canada for insolvency professionals is the CIRP, or Certified Insolvency and Restructuring Professional. That designation is offered by the Canadian Association of Insolvency and Restructuring Professionals. To obtain this successfully, you must complete the CQP program, which is, if you want to guess what the C stands for, if you guessed Canadian, you would be wrong. You must complete the CIRP qualification program to become a CIRP, C-I-R-P. So I'll have fun with this and I'll say it quickly. Once you pass the CQP to get your CIRP from the CAIRP, you then sit for oral board exams before the OSB to get your LIT. I understand this is thoroughly confusing, and I'm very close to this because I went through the process. It took me several years. It is a very rigorous program, just as I understand your investment professionals program in India also is quite rigorous. I would compare, just through my own personal experience, having become a lawyer and returning to study for my MBA, all challenging programs, but really they paled in comparison to the rigor that is required to become an insolvency professional in Canada. There are several steps, and each milestone is very challenging, and it is an elimination process. I feel very honored to have the LIT designation. Number 3 was information utilities. I understand the IBC regulates information utilities for credit information storing units to collate, authenticate, and disseminate financial information to facilitate proceedings. In Canada, the closest equivalent would be what we refer to as our official receiver, which, like the OSB, is created by the Bankruptcy and Insolvency Act and is appointed by the Superintendent in Bankruptcy for each judicial region. Each province in Canada, which we have provinces, you have states, has at least one official receiver. In practice, the official receiver acts as a repository for statutory filings and as an oversight policy body. So as a result, the official receiver only really becomes directly involved in a minority of the insolvency proceedings under the Bankruptcy and Insolvency Act, and the majority of duties of the official receiver are delegated to the private licensed insolvency trustees, myself, who manage insolvency proceedings. The fourth pillar was adjudication mechanisms. Canada has a central federal government like India and provincial governments equivalent to your state governments. Bankruptcy is a federal responsibility. However, the administration of justice, or the adjudication, is a civil matter which is handled at the provincial level. So you have two levels of government involved. So I have to admit, when I was listening to Dr. Pyla's comments, I was a bit jealous of India with your NCLT, or National Company Tribunal, and the DRT, or Debt Recovery Tribunal, and what you're referring to as the IBC. In my country, the administration of justice on bankruptcy matters falls to 10 provinces and 3 territories, each with their competing interpretations of the law. As it happens, some jurisdictions carry a bit more weight than others. Luckily for us, the Supreme Court of Canada is the unifying mechanism that is the highest law of the land, and decisions that make it to that high level are binding on all courts in the country. Within each jurisdiction, mine being the province of Ontario, the Chief Justice of the Supreme Court will allocate specialist judges and associate judges to hear insolvency matters. All of this was covered under the rubric of the Bankruptcy and Insolvency Act. Another important piece of legislation in Canada is the Companies Creditors Arrangement Act. Problems that developed in Canada during the Great Depression of 1929 to 1941 made it obvious to us that Canada needed legislation that would address financial difficulties of insolvent debtors to allow them an opportunity to avoid bankruptcy. And this relief did not exist at the time in the Bankruptcy Act. The possibility to compromise and settle debts was limited to a bankruptcy. Today, the CCAA is limited to companies with total liability claims in excess of 5 million Canadian dollars. A few other pieces of legislation that are relevant are the Wage Earners Protection Program Act. When a wage earner or a sales professional loses their job due to a bankruptcy or a proposal, the government of Canada has an insurance program that will provide them with a minimum of payments that are owed by the company, and then the government could then pursue individually the claims on a subrogated basis against the company. We also have a Winding Up and Restructuring Act, and that is similar to legislation you have in India, which basically provides an insolvency regime for various specialty companies, such as financial institutions, railway companies, national broadcasters. We also have a Farm Debt Mediation Act, which again provides separate rules that are applied when dealing with farmers. This was a broad overview of the insolvency regime in Canada. I've also been asked to discuss the framework for bankruptcy and restructuring in Canada for corporations. How am I doing for time? May I continue and cover the second part of this presentation, or would you like to move on? Okay, I'll cover the second part of the presentation then. A Canadian insolvency professional, or LIT, will view an insolvent corporation as having 3 basic options: bankruptcy, restructuring, and receivership. Bankruptcy. So the Canadian term bankruptcy is very different than what we would hear in popular media in the US terminology. We treat bankruptcy in the Indian terminology as a liquidation of a corporation. This is unlike the United States of America, where companies go into bankruptcy, they stay in bankruptcy until such time as their debt and capital structure is reorganized, and then they may come out of bankruptcy. This is not to say that bankruptcy cannot be a tool for restructuring. It is quite common in a bankruptcy for the assets of the bankrupt corporation to be sold with court approval to a related entity, and some variation of a similar type of company or business will continue to operate using the same location, equipment, even phone numbers of the bankrupt company. But the point I'm making is that the old company will be wound up and all the assets will be distributed in accordance with the priorities of distribution as outlined in the BIA. The most common areas that an LIT or insolvency professional is asked about in a small business bankruptcy has to do with liabilities at law that a director of bankrupt companies will continue to have at their personal level, even after a company has been liquidated. A very brief and partial list of these liabilities includes personal director liability for payroll taxes that a company has withheld from wage earners, and also taxes levied by a corporation for goods and services tax, which is our value-added tax. In both cases, and this is very important because this is where we get a lot of consultations, in both cases where a company has withheld these tax amounts that are to be remitted to the government, but has failed to do so, the taxing authority will impose a personal liability against directors, notwithstanding the company has gone through a bankruptcy. Directors can also attract personal liability for unpaid wages, environmental penalties, and for dividends that were paid out to shareholders when the business was insolvent. The second option for struggling corporations would be restructuring. And the premise behind restructuring in Canada is the same as it is in India. If a company finances are such that it may be able to generate positive cash flow for the indefinite future, which has a greater net present value today than the total value of the equipment, inventory, and other assets of the company, which are not encumbered by the claims of secured creditors, then it would be in the best interest, subject to the whims of secured creditors, it would be in the best interests of unsecured creditors to accept a partial compromise of the total dollar value of their debts, rather than voting against the restructuring and potentially ending up with nothing or very little in a liquidation scenario. A commercial proposal can be made under the Bankruptcy and Insolvency Act. The Act is not just for individuals. A proposal can be preceded by a notice of intention to file a proposal, also referred to as an NOI. I recall a time in 2018 that the president of a company and the corporate secretary came to my office on a Friday at 3 p.m. All they had in their hand was a list of current creditors or accounts payable and a letter from a creditor that they would be locked out by the end of the day. So the benefit of an NOI is that remarkably, we were able to prepare a complete NOI in 3 hours. We filed this with the OSB and we emailed it to the creditors in this case. A cash flow statement is required to be filed within 10 days of the filing of the NOI. But the point is, within 3 hours, we were able to immediately halt an event that was imminent, that was about to take place. Because when you file an NOI, this stays all proceedings. So it's a very powerful remedy.
So we cannot hear you.
You're on mute, I think. We can't hear you.
Hello, can you hear me now?
Yeah.
Yes.
Yeah. Well, where did I lose you? I'm sorry.
No, after you said that you prepared NRI in 3 hours, post that we couldn't hear you.
Oh, thank goodness. I'm glad that was just happened recently. So the point that I was making with an NOI, within a very short time period, you can create a very powerful legal proceeding that gets filed from your desktop, and it stays all creditors. And one is required to file a cash flow statement within 10 days after that, but just the act of creating that NOI and serving it on creditors halts them in their tracks on a moment's notice. It's a very powerful remedy, this NOI, and it initiates the formal insolvency proceeding. As mentioned earlier, companies with in excess of 5 million Canadian dollars can be restructured through the CCAA, or Company Creditors Arrangement Act. This statute is incredibly thin. It is not a voluminous text like the BIA. There are several benefits to using this more expensive process, but the overriding pro is the inherent flexibility of this statute, especially when issues involved are cross-border in nature. So if we had a filing that spanned India, Canada, and the USA, the CCAA would probably be the operative statute. You may not be aware of this, but 80% of all Canadians live within 100 kilometers of the USA border. I can attest personally that when USA courts are involved in a complicated restructuring, and on the Canadian side, the CCAA is the power that be, USA judges love and are very jealous of the speed and flexibility that this inherently easy-to-use statute has. Often it's the case that in terms of executing an agreed-upon plan across borders, it's the Canadian side using the CCAA that will have all matters locked down while American lawyers are still closing their briefcases in the courtroom. That might be a little bit of an exaggeration, or maybe not. If a corporate proposal under the Bankruptcy and Insolvency Act is voted down, similar to how Dr. Pyla described a creditor-driven process, if they voted down, this would result in an automatic or deemed bankruptcy or liquidation. On the CCAA side, if a plan of arrangement is voted down, the company is not automatically bankrupt because there is no provision for bankruptcy in the CCAA. A creditor or company would need to initiate that process separately. The last area I'm going to cover is receiverships. A receiver is a third party who is appointed by a court through a court order or by a secured creditor through a letter of appointment to take control of property, supervise liquidation proceedings, remit the proceeds according to the priorities established by common or statutory law. When a receivership is on an interim basis, the receiver is typically put in place by the court to protect assets, as it is done with short notice to the parties that are impacted. Interim receiverships typically precede a full-fledged receivership order. And by the way, in Canada, a receiver must be a licensed insolvency trustee or insolvency professional. In this context, the term receivership has often been synonymous with liquidation. A receiver comes in, fires employees, seizes assets, locks out management, and auctions off whatever is of value in the company in order to recover against its secured creditors. Often there is no bankruptcy after a receivership simply because there are no assets remaining after the secured creditor who hired the receiver claims their assets and the costs of receivership are covered, and resultingly there's no assets remaining, so there's no bankruptcy. In more recent years, there has been a trend in some cases in Canada to use receiverships as one tool in the restructuring process, sometimes on its own and sometimes together with a bankruptcy. So for example, as my last example before I hand it back, it is possible for a principal of a company, so you have your president or corporate secretary or director, to advance funds to a company as a way of a loan, so it could be a shareholder loan, your owner's equity, and take back a security in the form of what we refer to as a general security agreement, or GSA. It's possible for this insider to then enforce a shareholder loan against their company he or she is responsible to manage to satisfy the full amount of his or her secured claim against the assets of the company. And this would be to the detriment of unsecured creditors. I'm using this as an example because it does highlight the uniqueness of the Canadian system in some cases, because if the assets are sold by the receiver, it may be the very same group of insiders or the person who's the person or related entity that acquires the assets only to start up the same type of business thereafter. When related parties are involved in this manner, it requires court approval. And the issues, as one can imagine, can become quite contentious in nature, especially where professionals get involved in the process who are not necessarily familiar with the insolvency law and procedure. Thank you very much. I'm going to hand it over back to our moderator.
Thank you so much, sir, for your valuable words on Canadian
Sidra,
insolvency.
if I can take Mr. Paul's time for a moment, if it's
Yes,
okay.
sir.
Yes.
Yeah. Mr. Paul, like in India, we have recently, like in 2020, they have introduced insolvency framework for even personal guarantors. That is those individual promoters or directors who have given guarantee for a company, right? So they brought it under a similar jurisdiction of tribunals, that NCLTs, which we have the bankruptcy courts. So they brought them under a similar jurisdiction. They tried to keep the process simpler. Earlier, it was a civil court which was doing it. Even now, a civil court is doing it if it's a direct insolvency. But if it's an insolvency against a guarantor of a corporate, so we have a different procedure. So how is it in Canada? Like, is there some kind of an action taken against personal guarantors in this formal insolvency space as well?
That's really that's a really interesting variation that you have in India. The personal guarantors, if they're involved in a proceeding, it would remain in the main proceeding. There is no special process for personal guarantors.
Okay. And just one
I'm interested to
question.
learn more about that. I'm gonna definitely read up on what you're doing in India. That sounds very interesting.
Yeah, actually, they have devised a two-step procedure in India. One for the settlement, they're offering a process formally to settle with the creditors. If that fails, they end up in bankruptcy. So they're giving a similar procedure for corporates where we have a resolution and liquidation. On a parallel scale, they're also offering the same kind of procedure for personal guarantors. So that's how it is.
Very interesting. Very
Yeah.
interesting.
And
How
just yeah.
they distinguish between personal guarantors versus
Yeah.
the main proceeding. That's very
Correct.
interesting.
And then further, in case of avoidance transactions in Canada, like what we see in India is that the litigation is kind of unending, ending into like many years, and the recovery is very low for creditors, which is a matter of fact. There are like thousands of applications pending in the bankruptcy courts, pending litigation. They have not yet been ascertained because of lack of information or whatever. So in Canada, how progressive is this litigation on avoidance transactions? Can you throw some light on that?
I just need clarification on what you mean by avoidance transactions.
The preferential transactions, the undervalued transactions, which we identify, the clawback provisions which we have in insolvency. Usually,
yes.
yeah, the
Yeah,
preferential
so
undervalued.
I would say, okay, so what I'm most familiar with the United States outside of Canada, and I know in the United States they're extremely
Yeah,
aggressive with clawbacks.
yeah,
So
yeah,
you
yeah.
can have situations where you may have received a refund on your phone bill, and the phone company becomes insolvent, and you get a letter from a court official saying, hey, we have to take back that refund because you received a preference before other creditors. We're not there. So if you're comparing us to the US, we wouldn't be to that extreme, but we do have two types of avoidance transaction or clawbacks. One would be for preferences that are made to creditors over other creditors prior to the bankruptcy date. And the other one would be what we refer to as transfers at undervalue.
Undervalue.
So similar to India, we've tried to codify these and make it simpler in the BIA. Because as I mentioned, there's 10 different provinces and 3 territories, and in each province you have your own legislation. In Ontario, you have the Assignment and Preferences Act, Bulk Sales Act, Fraudulent Preferences Act, and there's several others. So we try to make it simpler, but lawyers still find a way to delve into the various provincial remedies. I would say on the whole, we probably could be doing a better job. I have seen preference transactions, and there's just sometimes there's a lack of interest to proceed with them, simply because in so many bankruptcy files there's very little funds in the estate to incentivize trustees and other professionals to pursue the matter. But where the dollar values start to become more significant, these do end up before judges and do get litigated for sure. Yeah, absolutely.
Thanks for the inputs, Paul. Thanks. That's helpful.
Thank you, sir.
Yeah.
Thank you so much, sir. Your expertise and knowledge on this subject were truly invaluable. Now, I would like to introduce our third panelist, Mr. Prakul Thadi. Mr. Thadi is a partner at Prakul and Kunwarpreet LLP. Sir is an insolvency professional and practicing company secretary, cost accountant, and lawyer. Sir is also the co founder of virtuallaw.in. Sir has served as assistant company secretary at the Nagpur Pharma, Telangana for 3 years. Sir, we would be honored to hear from you. Please address the gathering.
Yeah. Thank you so much. Firstly, I think I'm really glad that I'm sharing, with speakers like Mr. Paul on board. It's really proud for me to be a part of the panel. So thank you so much for inviting me on the panel. And as regards what I wanted to share was like, as I understand, we're talking about the evolving landscape of how the insolvency space is going in India. So being a practitioner myself, being an insolvency professional myself, I thought I'll throw some light on certain practical issues which we faced over a period and how they are being addressed by the regulator and how are we looking at it going forward. So I thought probably that can be of some value addition to the forum we have here and also the people who are attending this. So going by one such thing is I wanted to focus exclusively on the real estate segment, real estate sector of India, how the insolvency space now currently, how insolvency and bankruptcy code is helping the real estate sector or in a way not helping the sector. So I just wanted to throw some light on it based on my experience working in this space. So currently, I mean, from the beginning, I have been like handling a couple of real estate matters in India as an insolvency professional. I mean, as a resolution professional. So currently also I'm an RP of one real estate company in Bengaluru. So from what I understand, so from what it goes in the insolvency law is that we have one single code applicable for companies like kind of, it's like ready-made for all the segments, all sectors across the country. So even a steel company should go through the same process, or many pharma manufacturing company should go through the same process. A marketing company will go through the same process, or a real estate company also has to run through the same process. Now, there is no complaint on this. The idea of the law is also to simplify and regularize these kind of compliances or the processes so that there is certainty in the minds of investors and also certainty for the regulators and even for the foreign investors to see to it that, okay, for stressed assets, there is a prescribed procedure and there is no discretion on how it has to be run. That much it is perfectly ideal. But when we touch upon a real estate company, particularly in India, has has a lot of emotional element involved, which is otherwise majorly in other companies. Like for example, you take an example of a steel manufacturing company. Usually, it is funded by public sector banks or financial institutions, or maybe some other lenders or other companies. So usually, it is backed by corporate lending or financial institutional lending. But when it comes to a real estate company, it's usually backed by individual lending, particularly the home buyers, the retail lenders. So it's not lending as such, it's like an investment of the home buyers. And as you see from the Indian context, it's having your own house is kind of one of the most emotional thing Indian household would think of. And particularly from the middle and the lower middle class investors, home buyers who would invest their hard-earned money in a house property and later realize that the developer fails to repay that money, or let's say developers raises some portion of money from a bank and they fail to repay the bank, and the bank draws the company into insolvency. And as we know, in the Indian space of insolvency law, we have the moratorium applicable right after the company is admitted into insolvency. So technically what's happening is if a project is being constructed, it comes to a stall the moment IBC kicks in. And if a project is not yet constructed, for the entire period the IBC is in place, there would be no further construction on the project. So ultimately what's happening is these home buyers who have brought in their money are definitely the sufferers. That's the fact. But at the same time, what the law expects them to do is they expect them to be part of the committee to make decision making. So that's where we see that, for example, I go to the committee and I explain them, okay, fine, we have an investor in place. This is what he's proposing to do. Or I explain them that I think these are the security measures I need to do to safeguard the assets. Now, if I have a set of let's say 500 home buyers who have invested in a particular real estate company, obviously it is humanly impossible for me to deal with all the home buyers in a committee and take the decision making. And hence the law provided for the concept of an authorized representative, which was perfect. There is one authorized representative who is also an insolvency professional who will represent the interests of all the home buyers in this committee. So far, that's clean. But the challenge here is, going forward, like what's happening is in an event, there is no investor who has let's say, a viable interest in taking over the project. The site of liquidation seems to be pretty far-fetched when it comes to a real estate company. I'll give you an illustration as to why I'm trying to make this kind of a conclusion. Let's say we have a semi-constructed apartment, 3 floors are complete, and it's also complete in the sense that the floor work is complete and even the slabs are made. But it's a total project of, let's say, 7 floors. Now, at that stage, the company ended up into insolvency, and there is an insolvency proceeding ongoing. And there is nobody showing it. Let's assume for a fact no investor is showing interest to acquire this company or as a whole or to complete the construction, and it ends up in liquidation. Now, what do we sell? As a matter of fact, usually all real estate matters in India are a products of joint development agreements. And how it happens is that there is a landowner. We enter into an agreement with the landowner to develop a real estate project on that particular land. So technically, I don't have any title over the land. What I have are the rights to develop the property. So this is just one example of how things happen in real estate sector in India. This is commonly across India. I did matters in Mumbai, Chennai, Delhi, Hyderabad, even in Bengaluru. So the common fact is there is a landowner, there is a joint development agreement, and the company is the developer. So technically, we don't own the land. So there is no value ascertainable to the land. The value is ascertainable only to the developmental rights or to the flats which have already been developed. And majorly, those flats would have been secured to a lender. So the buyer, the home buyers, the individuals who have brought the lands, now they are clueless because number one, they don't own the flats unless the flats are completed, constructed and sale deeds are given. So till that time, they will be considered as a creditor, but not the buyer of the property as a customer. So now giving the money and then, like for example, like banker like SBI taking a haircut on settlement, let's say it has given 10 crores and it is being paid off only 5 crores. That is okay. At least to some extent, it is a commercial call. There was interest, penalties and all that. But for a home buyer, you can't cut the flat into 2 pieces, right? Either you have to do a completion of the flat or refund the entire monies. That will be the basic expectation of any home buyer. So I think with the evolving law, there is very important need to understand these kind of nuances for particular sectors and understand how to tackle it. Thankfully, somewhere, if I'm not wrong, in the month of June, I think last year, we had a discussion paper from IBBI. The regulator gave a discussion paper on dealing with real estate companies. Over there, they tried to focus on project-wise processes. Like, for example, a company has 3 projects. So they said, fine, let us divide these 3 projects into 3 different processes. You run the different process for each of this project. If a project is viable, a creditor, you ascertain who are the creditors who funded that project. Make it a separate process. Try to sell it separately. The moment you club all the 3 as one single company, it will be very difficult for you to, it might be difficult for you to find an investor. So that was a discussion paper, but it never ended up into law. Or it never, probably there are a lot of comments and observations from the professionals. Till date, we didn't see it to be becoming a law. But ultimately, what I feel is that with the kind of growth we are seeing in IBC and the trust in IBC, when it comes to real estate matters, the feedback from these home buyers and the ones who actually are impacted is not that great. Having said that, the alternatives are really worst. So technically, they are good to settle with IBC because alternatively, they don't have much of a option except for some criminal actions against the promoters, which would obviously not fetch them the desired outcome. See, I can go and get a complaint from a National Consumer Disputes Forum against the promoter to repay me the money. But if the promoter himself has no money, there is no point how we are going to solve this. So IBC does provide a very good platform in resolving real estate companies. But I feel personally, from my experience of working on real estate matters, there is definitely a difference in the way it has to be treated. We just can't give a similar treatment of any other sector, even to the real estate sector. So I feel that's one sector where there is huge scope for research, even students from the Symbiosis, you can also dwell upon understanding how real estate companies per se are handled. And across, and one thing to be noted is across continents, the way real estate happens is pretty different. Your manufacturing can be, there can be some commonalities across the nations, but real estate, it's pretty different. And it is always linked with the sentiments and emotions of the locals. So coming to the Indian context, we all are aware how emotional Indians per se are, and particularly when it comes to house and having your own house. So though there is economical factor which IBC talks about, I also feel there is a social factor involved, which not necessarily to be addressed by way of law in the sense of amendments or something, but probably some thought process has to go on in understanding how a real estate matter has to be handled. Is there a need to give additional time than what is prescribed under the current law to handle a real estate company? And usually real estates in India happen through SPVs. So you incorporate an SPV, that SPV will hold an asset. Now there is a holding company which is only investing in SPVs. If this holding company defaults, there is the lenders of this holding company come here, but the assets are all lying in the subsidiaries. So now how do you tackle it? Can you tackle both the subsidiary and holding company together, even though there is no default from the subsidiary? So there are multiple issues which are there in currently. I mean, I might have experienced very little compared to what are the issues many real estate companies are facing in India, particularly due to insolvency. And one such thing I can remember is that there was one instance where the homebuyers have given the monies, allotment letters have taken place, but unfortunately that money was only used, there was no land. I mean, just imagine there was land, but there was no building. There was not even a single brick they brought into the property. It was purely, absconding, and the promoters were absconding. There was nothing. There was just documents and the home buyers. There is no other lender. Now there is nothing. The law, what kind of powers does a bankruptcy court have in this case? They can't do anything beyond for some limits which are prescribed under the code. So when it comes to real estate matters, I feel there is a huge requirement to modify the way things are happening, and to also kind of fine tune the understanding of the fact that home buyers are not any financial creditor. They are a very different segment of financial creditors whose financial inclinations is different from that of a financial institution. So I feel I just wanted to leave it like this. I mean, it's not like I don't have an answer to this, but I felt, with the kind of evolution we see in IBC, this is one such area where I feel there's a huge need for research. And even recently, when I say recently, the last Tuesday, there was a paper in the Parliament on the pitfalls and solutions for insolvency and bankruptcy court presented in the Parliament by the Finance Standing Committee. So I think if any of you can grab a copy of it from the online, it would be really interesting for someone who's interested in IBC to understand the government's outlook at it. So the government is now thinking to reshape IBC to see, okay, where did we go wrong? Let us do better on that. So probably that can also throw some better light on the budding professionals like you to see where it is going, what is the direction of IBC in the country. And before I conclude, in 1985, we had the SICA, the Sikh Industrial Companies Act. And it was in 1986, the UK had got its own insolvency law. So though India was quite vibrant in having its insolvency framework back in 1985, but we know how big a failure it was till 2016. There was huge mockery at that particular legislation. And I always feel that had that legislation been amended or looked at the way IBC is looked at, we would have had the best insolvency framework. The world would have looked at us as from the insolvency framework point of view. The reason being that was a debtor in possession model. And there was a government involvement through a board called Board for Industrial and Financial Restructuring, which was looking at each scheme and trying to give customized benefits to the businesses so that they run. But they were focusing on only industries and manufacturing, and there was huge corruption. So that had completely spoiled the game for the country. And when we introduced insolvency and bankruptcy code in 2016, we shifted from debtor in possession to creditor in control model. So the moment you shifted to creditor in control model, where is the incentive of the promoter to support the process? So you are taking away the control from him. And through a section called 29A, you say that he is ineligible to submit a plan because there is an NPA. So technically, you're taking away all his incentive to support the process. And any promoter who would have run the business and brought it to a level would always want to take back. He would never want to let go. right? So there is some kind of a problem, particularly in real estate sector. We see that because all the investments happen because of the promoter and not because of the company per se. So I leave it here. Thank you so much for the opportunity. And if any one of you are interested to further understand or study on the insolvencies for real estate companies, I'd be very happy to collaborate. Thanks a lot for the opportunity.
Thank you so much, sir. Thank you for your insights. I would now like to introduce our next speaker, Mr. Pramod Srihari. Mr. Pramod Srihari is insolvency professional, a partner of CA firm Pramod and Darshan, and an associate partner at Optimus Resolution and Restructuring Advisory LLP. Sir has an experience for over 14 years as a chartered accountant and as an insolvency professional. Sir holds an experience as a president at Karnataka State Chartered Accountants Association for 2 years. Sir has also served as secretary there. Sir has worked as assistant manager at Bharti Airtel Limited, Chennai, India. Sir was an article assistant at Patel Mohan Ramesha. Sir, please address the gathering with your valuable insights on challenges and concern to keep business on going concern in CIRP.
Yeah, good evening, everyone. And it's very pleasant. I'm joining you all on discussion on IBC. And I should place my appreciation to Symbiosis Law School for conducting this session on insolvency and bankruptcy. And I'm really delighted to be on panel with Paul, Pyla, Narayan sir, Prakul, and Mohammed, who is going to speak next. There's a very interesting space which we have got, which is an insolvency and bankruptcy code, because each time India sees IBC in newspaper, it's always for the wrong reasons. One, it is because there is a lot of haircuts which have been given, and somehow this took major attention to all the newspapers as to why are bankers giving so much of haircuts in IBC. This although looked like a story which seems the IBC is used as a means to give a lot of haircuts to the businessman. Lot is said, I think, unfairly criticized for, but I particularly like everyone here to go and read the Indian Institute of Management Ahmedabad's report on the effectiveness of IBC, which was released in January 2024. It has some very interesting observations. One, it involves around 550 firms which went into the resolution process in IBC. And they have observed the same for the past 3 years post they went into resolution. And they found that the sales of such firms which went into resolution increased by more than 75%. Their capex expenditure increased by more than 130%. And their expenditure on salaries, or what we call as labor expenses, increased by 50%. That effectively shows that there is a huge benefit to the economy, to the nation, and also for the financial creditors if they go into the IBC. Well, the claims which the bankers would receive or the creditors would receive in IBC process is just 32% of the claims received, which is sometimes looks bothering. But I'll tell you one more statistics. It is 168% of the claims as far as the liquidation value. So while IBC may not be the best system, you may presume, but there is no alternative system which is available, which can be more better than this. So I thought I'll put context to it. There is a lot of positivity, while people may still be looking at very superficially, saying there are haircuts, this is not the right way. But India has moved, and this is one of the best, policy or code which we have seen. While very interestingly, there is something called a CIRP in Canadian law. I mean, I was very excited. What in India we call as corporate insolvency resolution process, there is something similar attached to CIRP in Canada as well. Now, there are 3 things which will happen once the company goes into CIRP. I mean, surely my 15 minutes wouldn't be sufficient for whatever topic which is given. I'll try to jump each of them very quickly. There are three outcomes when the company enters into resolutions in IBC. One, the application may be withdrawn. There can be resolution. the company can go into liquidation. And all the three cases are success of IBC. If it is withdrawn, you consider this as behaviorally, you're correcting somebody's way of seeing things. If the resolution happens, that's fine. If it can't be resolved, then that's the fate of the business, that it has to go through the liquidation, and that all the three are perfectly fine. Means of ending the resolution or the stress is what I believe. There are some very important provisions which enable the whole process of resolution. The first among it was moratorium. While I call it moratorium as a very powerful tool, is because all the cases, all the suits which are either existing or either which somebody tries to put on him will be on hold. This gives a great room for the insolvency the resolution professionals, the bankers, the creditors to go to their drawing room, see what is the best means to come out with a solution which can help the company to come out of the stress. So this moratorium of whatever 6 months or 7 months is an excellent tool for the companies while they are still working for the solution. And this is something which is very interesting in IBC. There is a very interesting case on Go Air, which I also wrote in one of the newspapers. It was the first time when one of the business houses in India used IBC as a tool to go to the courts, NCLT, and say that admit us into CIRP in order to save their assets, which were supposed to be given back because all this, aircraft were supposed to be given back because they were all on lease. Because once the moratorium is declared, all the assets are to be kept with the company and they need not even fly outside India. So for me, it looks like IBC is used as a tool to save the assets, to stay back in India and not to liquidate, and to run the company as a going concern. And this is a very interesting piece. IBC has some frequent repetition of words, and one of such word is called as going concern. And this repeats frequently. And the interesting part of this is that the company has to run into the insolvency resolution professional has to keep the company in going concern, try to resolve it as going concern. The resolution applicant should also buy this as a going concern. But mind you, there are companies which are per se not in going concern when they entered CIRP. Now, this is where that gets very tricky. The company is not in going concern when it enters, but IRP and RP are supposed to maintain the company in going concern and resolve it in going concern. These are some challenging things which are there. The experience of IBC has been varied. Prakul was very right when he said, when he spoke about real estate. It has probably resolved multiple companies, varied type of industries, which it has resolved, starting from hospitality, infrastructure, steel manufacturing, traders. There is software companies which are hardcore, intangible assets, and also on the real estate. When the first time the real estate came into the IBC and the project-wise CIRP was announced, I was really taken back as to how would a company which has assets be divided based upon projects be resolved. But that's still true. All the courts in India look at real estate as a project-wise, what we call as reverse CIRP. Now, if we have to take the argument a little more forward, could there be circumstances when there is a single company but have segment-wise businesses? Can we apply these also there to say that we will try to resolve by a resolution applicant segment-wise? Would that also argument be valid? I don't know. Tomorrow this can also come up, and this can also be left to the creativity of the resolution applicants, that there is one company which goes into CIRP, but there are 3 products which has 3 different segments, and there are 3 different resolution applicants who come and resolve. That's perfectly valid. Time will only tell, but I am also seeing that as a solution to the stress. So I spoke about going concern. The second thing which we talk about is on the creditor in possession. We have stopped, what we famously call as the paradise is lost. Defaulters paradise, is lost, is what we say. But we also have to look at one of the greatest hurdle when a company enters a CIRP, or the objections to CIRP comes from the erstwhile promoters. These are the first guys who go and object the petitions or the applications, and they are the greatest litigants. Now, creditor in possession probably aggravates the situation because they are not in control of it. But there is also one more fact, that the resolution professional or the interim resolution professional requires the support of the erstwhile promoters. It is not possible to run a company as going concern without the support of previous erstwhile management. It can be very theoretical if we are trying to solve this problem. That's also why I talk about three very important provision, which is on section 25, which talks on duties of a resolution professional. If there are 10 duties which the Act talks about, the first point which it talks about is to take immediate custody and control of all the assets. So taking control and custody of all the assets is the first of the duty which the resolution professionals have to do, and while meaning the custody of the assets, it also means the books of accounts and books records are also the custody, or also the assets of the company. I mean, that's how it beautifully defines. But there is one tool which the resolution professional has against the erstwhile management if they don't support, which is under section 19, where non-cooperation applications which we file. It is very frequently used application in the Indian context. Very frequently, we knock the doors of NCLT to say that our erstwhile management are either not cooperating, or it is not only the erstwhile management, it is even the personals, even the auditors, the application can be used on many, but it is very frequently used on the erstwhile management. And raising the interim, finances also is a very challenging thing in India. I think Prakul and all those RPs will agree with me that the market in India is not that mature that there is credit available for a company which is already into a CIRP. Not even to the company which is going through CIRP, there is no credit facility which is available to the resolution applicant also. No bankers would today fund a resolution applicant so that he can go and buy a takeover. So takeover finance is not as mature. Probably, by time when we see valuation, there is finance which is available, that would also, make it more interesting. And the second thing which is as a duty which I consider is very frequently used by a resolution professional is to determine whether there were PUFE transactions. By PUF, I mean preferential, undervalued, fraudulent, and extortionate transactions. These are also something which are very frequently used by the resolution professionals. In India, we more see closely held companies and group companies where there are transactions and related party transactions. And moment when there are related party transactions, the question of arm's length are always in question. And when the moment the arm's length comes into picture, especially in the real estate transactions and all of these, we see RPs and IRPs knocking the doors of NCLT against PUFE. And moment a PUFE is filed, you are taking the erstwhile management into the opposite side of the table, and then you see a non-cooperation. And this also has it is a vicious cycle, because the resolution applicant would not like to take this company until the petition under section 66, which is PUF transactions, are resolved, because he needs to know what is the asset which is involved in PUF transaction. So this is also something which hampers the resolution process. The second section, which initially I took was section 25. There's one more section which is on section 28, which is on the governance. While this is a very process which has many stakeholders, the governance of the company is also to be very carefully managed. Anything which is shady, or anything which is done in haphazardly manner can question the way in which the CIRP is run through. So that is why the section 28 comes in, where it says there are some transactions where it requires approval of committee of creditors. And these are also some things like, raising of interim finance, changing of the auditors, changing of the constitution documents like articles of associations or memorandum of associations, or transferring the assets, delineating any of the assets, or creating charge. These are all the transactions which the RP should not do without the approval of COC, because the governance is always observed, and there are people who would be questioning all of these. I thought this is one, and the last one is on section 30. More frequently, one question which comes in IBC is operational creditors do not get their set of due. It is the financial creditors who take the large chunk of whatever gets resolved. To some extent, in section 30, there is a saver clause, which is the operational creditors only get what is available for them at a liquidation value, not anything beyond that. We also see that happening in practical world, where the operational creditors will get a very small pittance of what is available for resolution applicant. While I know there is no other means which is more better than this, but there is some fair treatment to the operational creditors also would go a long way in improving the credibility of the whole system. I mean, I thought I'll bring it as a thing. And there is something called a section 238. That's also a very important section, a non-obstinate section, which says IBC shall prevail over all the laws. I mean, this section becomes so handy to resolution professionals, so handy to the resolution applicant, that that can be used as a tool, so that if there is anything contradictory to the other laws, there are some very stringent laws in India, like the PMLAs, what we call as Prevention and Money Laundering Act. There are these Benami Properties Act and other laws. IBC can surely overrule them, and it allows time for the resolution professional. It allows also the time for the financial creditors, COC, so that they can draw some solution. One thing which in India, which is not there, which I thought I'll probably open up for discussion, is we discourage a success fee for resolution professional. I don't know if Paul can probably, after my talk, can say, is there something which is common in Canada as well? In India, we had a case where the resolution professional charged a success fee, which is for these cases he resolved, but the regulators were not okay with it. They said, your job is not to see the success. Your job is to just follow the code of law and ensure that. But while on the other side, I will tell you, if it is not resolved, NCLTs have the opportunity to change the resolution professional. You don't become the liquidator. The NCLT has the power to change you from being the liquidator because you're not resolved. So while there is penal clauses, there is that you can be changed to need not be appointed as liquidator, but success fee is not allowed. I mean, this is a very funny instance. Success is not recognized, but failure surely is, like a goalkeeper. So, I mean, these are the, very broad thoughts. I thought, 15 minutes surely is not justified for the topic I had chosen, but whatever I could, I thought, I have covered. Anything more, if anybody wants, I can cover.
Thank you so much, sir. I would now like to introduce our last speaker for the panel discussion today, Mr. Farhan C. Mr. Farhan is legal in-house at Locad, Singapore. He is also the founder and CEO of Law Essentials. He is currently a part of PGIP at Indian Institute of Corporate Affairs. He has also been impaneled in the Independent Director Data Bank of the Indian Institute of Corporate Affairs. Now, I would like to request Mr. Farhan C. to enlighten us on the prospect of insolvency and bankruptcy in Singapore regime, recent developments in cross-border insolvency in CG.
Thank you so much. It's an absolute pleasure to be here. I'd like to thank Dr. Dari for the invitation, and along with Mr. Amar Afaq as well for being a facilitator for the event. While we did hear about the Indian perspective and several nuances under the Canadian perspective, and of course some perspectives of US from Paul's experience, I will now be speaking on the Singapore aspect. Singapore has one of the most modern insolvency legislations in Asia, as it has adopted the modern law to provide cross-border assistance. This requires that the Singapore courts recognize foreign proceedings if conditions are met and it is not contrary to the public policy of Singapore. I will also be covering a judgment which came out recently by the Singapore International Commercial Court in due course. It is also noteworthy to mention that in 2017, the Singapore Supreme Court instated the Judicial Insolvency Network Guidelines. These guidelines came out as a network of insolvency judges worldwide to facilitate thought leadership into cross-border insolvency and restructuring matters. Therefore, global companies which have a nexus with Singapore, let's say a company in India has a nexus with Singapore or a subsidiary in Singapore, is able to leverage its external resource. The primary legislation which exists in Singapore is the Insolvency, Restructuring and Dissolution Act of 2018, very similar to the Insolvency and Bankruptcy Code of 2016 in India. The act, very similar to what the circulars or the guidelines which came out or the regulations which came out under the IBC, has got 48 related pieces of subsidiary legislation under it. The purpose of the IRD legislation in Singapore is to combine and consolidate the laws which existed in the personal and the corporate insolvency sphere, and also to incorporate these amendments into the Companies Act which existed prior to the existence. The last aspect of how this establishment has occurred is that it regulates the insolvency practitioners. In India, it's known as insolvency professionals. In Singapore, it is called as the insolvency practitioners. It is also pertinent to note that the law, the recent act of Singapore which came out, was enforced in 2020 after the COVID came into existence. The COVID-19 Temporary Measures Act 2020 was introduced by the Singapore government. So this legislative measure ran in parallel to the IRD Act or the insolvency regime of Singapore. It is pertinent to note that the Singapore regime has an out-of-court judicial management. This allows that without a court order, the creditors, if the creditors are agreeing to a certain prospect, you can go ahead and resolve a company. There is no need of assistance of the court. This is very different from the pre-packed restructuring plan, which is still incorporated in the act as well. Ordinarily in Singapore, you will have to approve a scheme of arrangement by the committee of creditors and then get it approved by the court. But in the pre-packaged regime, you can directly resolve a distressed company in case the creditors apply to approve the pre-negotiated scheme. To become an insolvency practitioner in Singapore, you can be a solicitor, a public accountant, a chartered accountant who has relevant experience. Very similar to what is known in India as the insolvency resolution professional or the resolution professional. In Singapore, the persons are known as the interim judicial managers or the judicial managers. The Act also came out to maintain measures and better standards in the professional body of insolvency practitioners. In the previous regime, the licenses was administered by the body in terms of different qualification requirements, and several bodies existed under it. But under the new regime and under the new Act, which came out in 2017, the licensing and the regulatory framework instituted by the Act centralizes the licensing requirements. Also, the persons who are registered as insolvency practitioners have a registration valid for 3 years. Along with the new licensing regime which came about, there is an exposure to of these practitioners to legal liability in certain situations. Another striking feature of this act is the restrictions which have been placed on the ipso facto clauses. So what are ipso facto clauses? These are clauses which are incorporated in agreements which essentially trigger contractual rights upon restructuring proceedings. Let's say there is a clause in the agreement which says that a party on its own accord can, without the consent of the other party, terminate the agreement or make substantial amendments to this agreement in case the other party goes into the insolvency. Such a clause will be ineffective under the law, as this will hurt the company's restructuring prospects when it is already in a vulnerable state. The restrictions complement the existing laws which come into the sphere and give the breathing space which is required to restructure debt. In particular, the restrictions would allow that the ongoing projects or the contracts continue, so that the distressed company is able to revive This also brings it in line with what exists in the regime. I think it could be in Canada, Australia, and the US as well. The new regime also brought in a prospect of a wrongful trading provision, which provides that a criminal liability is no longer required as a prerequisite before a civil liability can be imposed. A person can be found liable for wrongful trading and be personally made liable for the debt without having a criminal liability established against him beforehand. While I was hearing the interim financing aspect mentioned by Pramod earlier, there is an aspect of third-party funding which is included in the act. Distressed companies often do not have sufficient funds to pursue the claim. Third-party funding will enable them to pursue it. Within the act, there is provisions to invite several cross-border or foreign entities to come in, restructure debt, etc. And these companies, very similar to the regime in India of the interim financing, in Singapore, it is known as the rescue financing, which provides a higher priority to such creditors who provide amount at such times when the company is in difficult situations. Moving towards the Singapore International Commercial Court, in October 2020, the procedural rules of the Singapore International Commercial Court was amended, and it was allowed, or it was given the jurisdiction to hear cross-border insolvency, restructuring, and dissolution proceedings. On January 2024, a panel of judges, I think one of the judges had tried to invite for this event as well, Justice Staunchi, was unable to be a part of this panel. The first insolvency-related judgment came out by the SICC just recently on 18th January. It was the Garuda Airlines of Indonesia, which had approached the Singapore International Commercial Court to hold the restructuring proceedings ongoing in Indonesia as the foreign main proceeding. They claimed that Article 17 of the Singapore Model Law makes it mandatory for courts to recognize a foreign proceedings once the substantial procedural requirements of that articles are met. So the court went on in this scenario to hold that there is no aspect of public policy which is being contradicted, or no aspects of contraception done in this sphere. This judgment of the SICC gives a clarity for even Indian companies which has subsidiaries in Singapore to come before it to restructure debt. It sets a precedent for recognition of the foreign insolvency proceedings, offering a more predictable legal framework to restructure debt. That's it. Thank you. Thank you.
Thank you so much, sir, for addressing us with your knowledgeable words. I would request the faculty in charge of International Cell, Professor M. Rafaq, sir, to deliver a vote of thanks to our guest for the panel discussion.
Thank you very much, Sadra. Before we proceed for the vote of thanks, I would like to request the participants that the chat box has been enabled. In case anyone have any kind of question for any of the panelists, please feel free to write it down in the chat box. So we'll be waiting for a couple of minutes.
Before that, if I can, Farhan, just one question. Last example you've given, like if suppose an Indian company has a subsidiary in Singapore, then where is this foreign recognition of foreign proceedings? How are you even talking about it? There's no foreign proceeding as such, right? It's a subsidiary incorporated in Singapore.
Right. So if there is an insolvency proceeding in India, a CIRP is going on, and moratorium has been placed by the by the NCLT as such. The Singapore court, the Singapore International Commercial Court, will recognize what India's NCLT has given as the foreign main proceeding and help to restructure debt accordingly, even in its subsidiary which exists in Singapore.
Okay, but ideally we have not initiated any insolvency against the subsidiary, no? Subsidiary.
Right. If it's the main company which has been done, right, it automatically emanates.
Is it? No, ideally, see, generally all these corporate insolvencies are particularly to that particular corporate. Like Jet Airways is one case where we had a local office in Netherlands. It's not a subsidiary. And hence, therefore, there is a foreign main proceeding which is being recognized there. But in this example, anyways, I'll connect with you separately. But yeah.
Sure.
Thanks.
We have a question in the chat box for Mr. Paul.
Yes, the question comes from Kartike. Can a debtor propose a consumer proposal as an alternative to bankruptcy in Canada? If so, what are the eligibility criteria? Consumer proposal is a way for a debtor to acknowledge that they owe their creditors, and is a way of having them provide as an alternative to a liquidation event, offering some amount as a percentage of the total amounts that they owe in repayment. The qualification for that is that the total debts that are owed by the by the debtor, must not exceed Canadian $250,000 without including any secured debt that they have on their primary residence. So you could have $1 million home with 750,000 Canadian dollars of debt, but you owe in credit card and line of credit, etc., $200,000. You are eligible to file a consumer proposal. The incentive for creditors is quite obvious. If there's a compelling case made to them that they would be much better off taking 30 cents on the dollar than they were to having that debtor go bankrupt, they will and they do accept the proposal. The terms of the proposal cannot extend beyond a 5-year period. So typically we'll see, $100,000 of debt compromised to $30,000, and that gets paid over 60 months in equal payments over the monthly period. It's a particularly useful mechanism because it's very rules based. The BIA spells out in great detail exactly how this procedure works. There's very strict time schedules, very strict ways in which the creditors and debtors communicate with each other electronically. It's extremely efficient and streamlined, and allows individuals to avoid the stigma of a bankruptcy. Now, I should mention a consumer proposal is only available to individuals. It is not available to corporations. Thank you so much for your question.
Farhan, I believe there is one question for you. What is the role of the official assignee in Singapore's insolvency process?
Right. So in respect of what insolvency or official assignee person can do in such a sphere is he does judicial management, wherein very similar to India, he would be leading the meetings of the committee of creditors as such. So that is what is done. And in cases where such a committee of creditor meeting is not relevant or it can be dispensed with, he will directly proceed towards the court.
Okay. So we have one more question for the panelists who have dealt with the Indian perspective. If any one of you would like to take it.
Prakul, I think.
Yeah, I'm here, sir. So
Yeah, can the pre-pack
pre-pack
insolvency
be
resolution
extended-
process be extended beyond MSMEs in India?
And can it be considered as an alternative to CARP is the question. So, I mean, in my opinion, per se, pre-packs till date have not yet been a successful mode of debt resolution, considering that we haven't seen much of a progress on pre-packs for MSMEs. So probably that leaves the question, should it be going beyond MSMEs so that other companies can also make use of pre-packs? The challenge is, even if it is allowed procedurally, the way pre-pack has been designed, it is designed only for small entities. The moment you have too many creditors in place, implementing pre-pack practically will become a huge difficulty. That is number one. And because there is a concept of base resolution plan and there's involvement of judiciary at several stages. So I don't feel it's a right stage for us to make it an alternative to CIRP. That's my opinion per se. There's no answer to it. In my opinion, firstly for MSMEs, if we can make it a successful mode of resolution, and probably then we can think of exploring it on as an alternative to other processes. That's my opinion.
If I can add to the point, pre-pack came into existence because of COVID. So there is one thing which happened is world over, it was presumed that a lot of companies will go into insolvency. Interestingly, in India, that did not happen because there was this credit which was extended to the companies. So not many companies went into insolvency because of COVID. And world over, that's also the case, is what I have heard. And that's why the pre-pack did not come. Pre-pack was an answer to it, one. Second, there are only 7 cases in all over India where pre-pack has been used in past 1.5 to 2 years.
Yeah.
And only interesting fact there is that the operational creditors are given a good amount. I mean, unlike the other one. Yeah. So while the answer to the resolution is very nice, but the numbers are very discouraging. So even if it is given to non-MSMEs, we don't know how much it is. But while I saw in one of the newspaper headlines that it is extended, the government is thinking of extending it to non-MSMEs as well.
One more question on Singapore.
Right. Though the creditors' rights are protected, wherein the judicial management, the creditors have a role to play to approve the plans which are going on in the process. They will also facilitate the whole process and understand. Right. Also looking towards the last question, the minimum amount of debt which is required is to the tune of SGD 100,000. So that is the minimum amount of debt with which a creditor can file for the judicial management process to be initiated in the Singapore court.
I believe that's it. If the person in insolvency, how they manage liability, and who decides the person is insolvent.
From the Indian context, you need to have a debt of more than 1,000 rupees. Default, sorry. That's what the Indian insolvency law actually states. If you have a default of more than 1,000 rupees, though it doesn't declare you a bankrupt or an insolvent, but proceedings can be initiated. However, they are not in force as of now, not effective for all individuals, except if you are a personal guarantor to corporate debtor. And yeah, if the ultimate bankrupt and insolvency is two different theories which we need to understand here. So I feel, yes, it's the liability part is again based on default in India from the Indian context.
Thank you very much, Prakul sir. So I believe with this, we would like to come to an end of this very enlightening panel discussion. I am Rafat on behalf of the Symbiosis Law School, Nagpur, Law Essentials, and our knowledge partner, Optimus Resolution and Restructuring Advisor, LLP. Would like to express my heartfelt thanks and gratitude to each and every one of you for gracing us with your presence and enlightening us with your thoughts. When we consider the success of any event, especially in the virtual world, in online sessions, every one of us might have their own litmus test to determine that whether the event is successful or not. For me, the success of online event is gauged by the fact that when initially we have started the discussion, what was the number of participants we were having and how many have dropped in between. So I'm very satisfied by the fact, and I'm happy to share that we never came down from the number we had in the beginning. We only get up from there, and that for me, as I believe, is the how enlightening this session was, and what kind of a learning the students must have taken from the discussion. It's a long list to thank each and everyone. So let me start with my esteemed panelists for the day, because they have shared their profound insights, expertise, and diverse perspective on insolvency and bankruptcy code. So let me start by extending my heartfelt gratitude to Mr. Paul Franchi. Thank you very much, sir. It was a pleasure to have you with us today, and the perspective you have shared on Canadian IBC was quite in-depth, and it also shows the way to our students to how to proceed with certain things. I would also be extending my heartfelt thanks to Dr. Pyla Narayan Rao. Thank you very much, sir. When you have started, the element of an academician was truly reflecting when you have taken the issue of the way you have gone into the nuances of it and how the way you have shared your expertise with us. Thank you very much. My heartfelt gratitude is due towards Mr. Prakul Thadi, sir. Not only he has enlightened us with his thoughts and shared a valuable expertise, but also the way he has, haven't hesitated in bringing up the different aspect that was there in his mind, truly making it a panel discussion was indeed appreciable. Thank you very much, sir. My thanks, heartfelt gratitude to Pramod Srihari sir as well for being there, for taking his time out and sharing his views, his thoughts with us. And of course, Mohammed Farhan. Uh, he was the brain behind all of this, and it was initially his proposal that the Symbiosis Law School Nagpur have taken forward. So I'm thankful to you, Farhan, not only for being the backbone of this event, but also sharing your expertise and helping us as an institute to bring so many big names on a single platform. Thank you very much. You know, I'll be failing in my duty if I won't be thanking our director, Dr. Sukhvinder Singh Dari, who have been that pillar of support to us, never saying no to anything which we have proposed. We are extremely thankful to you, sir, for your consistent support and the way you are guiding us in all ebbs and tides of our life. Also to Professor Jimmy, the faculty in charge of training and placement cell, for collaborating with the international cell and doing all the work that was required on his part. My extreme thanks to Sidra Kashyap for taking the time out and moderating the session. Of course, the participants, more than 150 students have joined. In fact, even now, when we are at the vote of thanks, we have 146 students remaining with us. Thank you to one and all for your interest that you have shown, and I hope that you have a lot of learning to take from this panel discussion. Also, the members of Training and Placement Cell and International Cell, thank you very much. I know the kind of efforts you have put in from the last couple of days, arranging all IT work and other manuscripts. Thank you very much. Last but not the least, the IT team and the support staff at SLS Nagpur, without whom this would not have been possible. Thank you very much for your support, and thank you very much for staying back after the office hours as well. With this, thank you very much to one and all. And it was indeed a great session, lot of learning, and I hope that soon we all will be having an opportunity of meeting in person, and we will be more than happy to host all of you in the Symbiosis Law School Nagpur with a similar kind of a session. And even if small modules can be developed for our students, and you can come and share your practical experiences and insights with our students. Thank you very much.
Thank you so much.
Thank you.